when Wells Fargo stole people's money, we made them pay them back. When a greedy health insurance CEO ruined someone's credit, we canceled $50 billion in medical debt on their credit reports. And when big banks like Capital One or payment apps like Cash App rip you off, we make them pay you back. We protect your paycheck and the mortgage on your house. But not right now. Right now, there's no one overseeing the big banks. All our favorites, PNC, Citibank, Bank of America, many more, are operating lawlessly, without oversight, thanks to Elon Musk and Russell Vogt. So that's why we're here today, and that's why this hearing matters so much today, y'all. Musk and Vogt believe that it's CEOs who should run this country, not the American people. I disagree. CFPB workers work for the people, not the banks and not the CEOs, and not for billionaires like Elon Musk. What Elon and Vogt are trying to do is unconstitutional. It's un-American. It's unpopular. And it's an attack on working people. We're going to keep fighting every day. We are entering week 4 of being locked out, banned, censored from doing our work. But here we are, still here, trying to fight back so we can get back to work protecting Americans from corporate greed. Now, I want to take a moment to acknowledge the uncertainty of what we're dealing with here today. Today, we're going to fight in court. Legal battles are critical for us, right? But legal fights are not the only fights that we could fight. There are fights to unionize and support other unionized workers. There's marching and rallying in the streets. There's one-on-one, person-to-person organizing. That's getting to know your colleagues, talking to each other, your neighbors, creating networks for care and solidarity. No matter what happens in court today, let's remember, we are the second agency Musk came for after USAID, right? And so we're teaching workers everywhere how to fight back in the face of corporate greed. This is our 7th time out on the streets in the last couple of weeks, y'all. That's incredible. CFPB union members are rallying nearly every day nationwide in Chicago, New York, San Francisco, and here in DC. And we've had people show up at Tesla, outside of big banks to picket all across the country. So let's give ourselves a round of applause for all the organizing we have done to get us here today and all the fights we're going to have in the future. I also want y'all to welcome next. We have speakers who were amongst the illegally, unjustly fired cohort of our comrades here at CFPB Union. And so they are going to share their stories about their experience working at CFPB, going through this illegal, unjust treatment of getting fired, and how they're fighting back.
Big round of applause for Kat, everyone. Kat is out here inspiring us every day to fight for one another and remember to stay strong in solidarity. So thank you, Kat. We show up for each other. I'd like to invite Jasmine Mallister to the stage, all the way from New York City. Come on up.
I say people, you say power. People.
Power.
People.
Power.
Good morning, everybody. We, the people of the United States, voted for Congress, who in turn created CFPB to prevent the abuses that led to the 2008 financial crisis. Like several government agencies, we're under attack, but we rally here today because we won't stand idly by as our government is dismantled. We do the important work of protecting the everyday person from Wall Street scammers and predatory lenders. My name is Jasmine, and I was illegally fired, but my still employed coworkers were told to stop working, and we just want to get back to work. Let us work! Let us work! Let us work! My colleagues are some of the most dedicated people I've ever met, and we take our job seriously. We serve in good faith and are not subject to political whims. Everybody here, on our first day on the job, We swore an oath to the Constitution. We didn't swear an oath to a king. We didn't swear an oath to a political party. And we certainly did not swear an oath to an unelected billionaire. How do you spell corruption? E-L-O-N. How do you spell corruption? E-L-O-N. How do you spell corruption? E-L-O-N. The past several weeks have felt like years. Our strength has been tested. Our resolve has been tried. We have shed many tears. After today's hearing, we may be able to work again, or we may be set back. But our spirit cannot be broken, because we embody the spirit of America. We fight for freedom. When your bank account keeps hitting zero and the bank charges you illegal overdraft fees, that's not freedom. We fight for liberty. When used car lenders deceive people and illegally trick them to pay more money, that's not liberty. And we fight for justice. When an unelected billionaire hijacks our government, that's not justice. When democracy is under attack, what do? Stand up, fight back. What do? Stand up, fight back. We the people do have democracy under attack. We the people voted for a government that serves human well-being rather than profit. But instead, greed is taking over. But we the people have the power to fight back against those who subvert the ideals of America. The fight for liberty and justice is much bigger than us gathered outside the courthouse today. It's a fight that began long before we were born and will continue long after we're gone. Wealth and power will always be hungry. Wealth and power will always seek to oppress we the people. Their strategy is to cause chaos and confusion. Their strategy is to bully us. Their strategy is to traumatize and demoralize us. But that's why we're fighting back in the courts and in the streets. There are hundreds of us here today united. I want you to look around at the people around you. Make eye contact. Acknowledge each other. You personally, each and every one of you in this crowd, you are fighting for each other. We have the full force of money and power against us, but we have, we have the full force of money and power against us. We have the law on our side, but we have the law on our side. We have the American public on our side. We have justice on our side. And most importantly, we have each other. The people united will never be divided. The people united will never be divided. The people united will never be divided. Thank you, everybody.
Thank you, Jasmine. I'd now like to invite Alexis Goldstein up here, all the way from Drop Off, here to speak to us. Gotta lower it a little bit. Hey! Let me try that again. Hey! So we're here today to fight in the courts, but like Kat said, you know, the courts aren't going to be the only one to save us. We are going to be the ones to save us. And we are under attack by a greedy, corrupt billionaire who first came for USAID, then came for CFPB, is coming for everybody else next, 18F, GSA, you name it. He's also a huge loser. I don't know if you've followed him. He paid someone to make him seem like he was good at video games, and it was a lie. A lot of the people that he hired to be his little henchmen tried to get hired by the original U.S. Digital Service and were rejected because they weren't actually technical enough to do the job. So I think, you know, we're up against a lot, but let's remember not to be afraid. We have the public on our side, like Jasmine just said. We have the law on our side. We have our neighbors on our side. We have all these awesome people driving by on our side. And I think, you know, we as federal workers, we just want to do our job. I loved my job. I don't know about you. When I got fired, like, this is the best job I ever had. It was heartbreaking to be fired, to be illegally fired, I should say. But I think the most important thing is that fear is very contagious, right? I think a lot of people are seeing what's happening, the shock, the awe, the news stories, and they get scared. And they see their coworkers scared. And that
makes them scared. Fear is contagious. But do you know what else is contagious? Courage is contagious. So if your coworker sees you standing up or filming someone or sending an email or writing an amazing declaration in the lawsuit, whether that's with your name on it or anonymously, that courage is contagious too. So let's be courageous for each other. And I think the only thing that is not more contagious than courage is fun. So let's not let these folks scare us. Let's remember that they're goofballs and that we just want to help get the American people's money back. When banks steal your money, we get it back. When a car lender, a title company repos your car and you didn't even have a loan with them, which is the thing that happens, we get your car back. And we were created after the financial crisis because none of the other regulators stopped it. Congress said, you know what, the Fed's not enough, the FDIC's not enough, the Office of Thrift Supervision, forget it. They missed it. They effed up. So that's why we were created. Congress created us. Only Congress can uncreate us. So thank you all for being here. Let's remember that courage is contagious. Have fun.
Thank you, Alexis, for such a timely reminder. And I'd like to invite up not necessarily a coworker, but someone who stands in solidarity with us, the president of our national NTEU, Doran Greenwald.
What a great crowd to see here today. We are here to right a wrong for this country and CFPB employees. It is ridiculous that we even need to spend our energy doing this, to stand up for the CFPB that does nothing but give back to the American people. Ask yourself, why an agency that's sole purpose is to stand up for consumers and has delivered over $21 billion with a B dollars back to every American that has been the victim of fraud or people trying to take advantage of them, would be on the top of the list to stop. Something is wrong with that math. Who's behind it, we know. Ever since the decision was made to shut the doors and tell the federal employees who believe in their core about the mission of CFPB, sorry, I lost a letter there, that they couldn't do their jobs, I've watched the workers of CFPB take to the streets. They have been out there in the rain, the snow, the wind, spreading the word that you are not going to make us back down. We know the important work we do for the American people, and there is nothing going to stop us take away our rights and fight back for the oath we took to the Constitution and the American public. Let me ask you, if you could give $1 and get $2 back, would you think that's a good investment? So why would we want to shut an agency that does that for consumers? The fact that over $21 billion has already been collected, not only is that a good number, but that should tell you the broad scope of the fraud and abuse out there for the American people. Who is going to do this work if not CFPB? That's the very reason they were created, because nobody was looking out for consumers. We should want people in our government who are fighting for the American people, and that's exactly what CFPB does. So, we are here today to go to court to right this wrong. We are going to keep fighting to restore CFPB and put our federal employees back to work for the American people. And we aren't going to stop until we get there. So let me be clear. We all have to fight for this together. We cannot shirk back. They are looking intentionally to cause anxiety, chaos, and make you fearful of them. How do we answer that? With power, strength, confidence. We know the law's on our side. We know the American people need us, and we are going to live up to our oath to that Constitution and deliver until we make this right. So join me as I head into court. Thank you, everybody.
Thank you, Doreen. And yet another reminder that we're stronger together. NTEU National has 130,000 members. And together we can harness that power to make sure that we're able to continue doing our work that's so important. I'm going to take a pause for just 1 second and say those of you who are planning to attend the hearing inside, now is a good time to head in and start going through the process of getting in. I will remind you to please take off any buttons or anything with writing. Take off your solidarity shirts. You'll take the solidarity in your heart, but not on your t-shirt. Please go ahead and start making your way if that's part of what you're doing today.
My name is Nicole. On February 11th, 2025, I was fired from my dream job as an honors attorney in the Enforcement Division. I was fired along with 130 other probationary employees at the Bureau. We were fired via email through some sort of sick, twisted, failed mail merge attempt that had empty fields in it. They didn't have the balls to even put my name on the document. They backdated the date of my firing. I was fired Tuesday night, the 11th. They told me I was fired on the 10th. They deleted my Concur profile with a voucher pending, so I had to pay over $1,000 for a trip I took in January. They took weeks to tell me how to continue my health care coverage. They took weeks to give me my required documents to apply for unemployment insurance. And ultimately, they gave me no severance, no advance notice, no opportunity to find other work. I was new to my job. I was 4 months in. I was green. I knew, along with other probationary employees, that there was a chance that Trump would win the election. I knew, going in, that there was a chance that my job would get harder. There was a chance that I would work for leadership that didn't think that our agency should exist. I knew that going in. I knew when Trump won that I would have to fight harder for my cases. I knew that I would have to work harder. I knew that I would have to fight harder for the American consumer. But I knew one thing. I knew I was going to bring righteous cases. I knew that I was going to win. And I knew that they were not going to get me because I was lazy or unproductive. I was the most productive I've ever been in my entire life these last 4 months. It was the honor of a lifetime to spend these 4 months with you all. And I'm going to tell you something. I was not naive. I knew that they would likely fire me as a probationary employee when I saw that Trump won. I knew that. I had my eyes open. But what I never expected was that I would be fired at 9 p.m. on a Tuesday through email, through a failed mailed merge, without the balls to tell me to my face that I was being fired because they were being cheap. This is not because of efficiency. This is because we are an agency that speaks truth to power. They're threatened by us. And that is why we were fired. That is why they are trying to delete us. And let me tell you, I am not going away. We are not going away. I deserved so much better. We deserve so much better. Consumers deserve so much fucking better. I'm ready to fight. I'm ready to continue fighting. Who's with me? Thanks, everybody.
Thank you, Nicole. All right, I'd like to invite Graciella Aon Diaz up to the stage. There you are.
All right. They took my computer and my printer, so you'll have to excuse me. All right. So, hi, my name is Graciella Aon Diaz, and I'm here to fire back. I was a housing counselor 20 years ago during the foreclosure crisis. I can still remember the faces of the people that came to me when they were losing their homes to foreclosure. I can still feel their pain, and I carry their stories with me everywhere I go because they give me the courage to stand up and speak up for them. The CFPB was created after the foreclosure and economic crisis of 2008. The CFPB is the only agency that protects consumers from unfair and abusive services. Before I was illegally terminated, I was helping the enforcement team with a case against Heights Finance. I traveled to Brownsville, Texas, a border town. I met people who had personal loans from this lender. Their loans carried an interest rate of more than 100%. And they were often tricked into multiple refinances. Last week, the Trump administration dismissed this case and 4 more. They were dismissed with prejudice, meaning the CFPB will not be able to revive any of these cases in the future. To channel Kendrick Lamar, Elon Musk is not like us. Trump is not like us. Billionaires are not like us. We are federal workers. We are people. We are consumers. Getting fired from me means 0 health insurance for me and my family in 2 weeks. And that's if I'm lucky, because some of my coworkers have already lost their health insurance. Why? Because CFPB workers have been locked out. They've been asked not to work. There's one HR person managing all of this, and I still haven't gotten my separation package. Shutting down the CFPB won't save the government a penny. The CFPB is funded by the Federal Reserve, which gets its money from bank fees, not taxpayers. In fact, the CFPB puts money back in taxpayers' pockets by fining banks that break the law. If it's truly about efficiency, they should stop giving billionaires tax breaks. Trump and Musk want to shut down the CFPB for their own financial gain. Musk's new Visa credit card would be regulated by us. How convenient. We must stand up for economic justice. So I ask you, call your congressional representatives, come to peaceful protests and boycotts, write letters, go to town halls. Together we can protect the CFPB. Together we can protect our democracy. And I'll leave you with this. If we don't resist and we allow Trump and Musk to persist, the CFPB will cease to exist. Thank you.
Thank you, Graciela. That's right. They are not like us, but we are like each other, and we are here for each other. All right. Is Elana here? I saw you somewhere. All right. We will circle back to that. Oh, there you are. Sorry. Come on up.
Right. Hi, everyone. I'm Elana Idis Clock. I'm an honors attorney in supervision. So I'm 7.5 months pregnant. Half of my honors attorneys class has been fired. We don't know why. We don't know why some of us have been fired. some of us still have our jobs. Some people have gotten their jobs back via email. We don't know, no one knows what's going on. No one can answer any questions. Like previous speakers have said, people are losing their health insurance. I don't know if anyone knows what the cost of giving birth in America without health insurance is. It's like a mortgage. So it's not an ideal situation. I'm on the mortgage team in supervision. One of the projects that I work on is an alternative mortgage products. We look at startups, fintechs, companies that are trying to bring new products onto the market, products that these companies don't believe are subject to our supervisory authority. So what does that mean? When you look at these deeds, when you look at what's happening, people have insane terms. They've got balloon payments, they've got interest rates, we've got people who are not able to make their monthly payments because their monthly payments are double what they were paying before they signed these contracts with these new companies. We're not doing that work anymore. I don't know who's doing that work. No one's doing that work. And this is something that is growing. It's a growing industry. One of the companies we were looking at is the 30th largest household homeowner in the United States, and all these companies are growing rapidly every year. So this is something that we're really concerned about. When we're looking at keeping people in their homes, you know, we've got the products that we know and that we supervise, and we've got new products coming onto the market. The CFPB, our teams are some of the only teams in the country that are doing the research and figuring out ways that we can keep people in their homes and educate people so that they can avoid these types of predatory practices. So we'd like to get back to work on behalf of the American people. Help us get back to work.
Thank you, Elana. All right, so
thanks to everyone who spoke today. We stand in solidarity with the folks who have been fired and the workers who are here to try to fight for the life of our agency. As someone said, the people united will never be divided. And remember that as you stand out here in the freezing cold to fight for our agency. I am Antonia Cofy. I'm a member of the organizing committee. I've been with CFPB for 12 years. I started in the great Office of Consumer Response, and now I work with the Office of Consumer Populations that highlights but the office highlights some of the specific populations, like our service members who have been taken advantage of by shady auto lenders who, they set up outside of military bases waiting for those people to come by and try to steal their benefits and violate the laws that we have to protect those people. They come after older populations. We are over here trying to help people avoid scams. People who are underserved, young students who are trying to pay for college and enter adulthood. These people want to stymie all of that. But we are here to talk about the timeline of an attempt at a takedown of CFPB. And I want to say, number one, thanks to the folks who spoke out here, but also thank you to the folks who bravely decided to contribute to the statements to support the court action that are inside the court right now, that took bravery, that took courage. But we together, we will take down these people who are trying to break up our agency. So we know that this didn't start on February 11th, when they shut down the building like cowards and told us that we couldn't come in. It started before it was a plan. So we have a timeline of a takedown with the declarations of people who bravely shared what was happening behind those closed doors with emails and conversations. And we're going to read some of those to you, okay? All right, so we're going to start with January 20th. Here's what Seth Frotman former CFPB General Counsel and Senior Advisor to the Director swore to in his declaration. In response to OPM's January 20th, 2025 guidance, I consulted formally, orally, and in writing with agency leaders about the CFPB's employees on probationary periods to determine whether those employees were necessary for ensuring compliance with the agency's statutory objectives and whether there were any performance issues with those employees or any other non-political reasons for their termination. Based on these consultations, the CFP assessment was with those employees were indeed necessary to support the CFPB's ongoing functioning, including to meet its legal obligations. The agency did not identify any employees on probationary periods with their performance or conduct issues that would have justified their termination. Indeed, my consultation with agency leadership, not a single reason for terminating any employees on probationary periods was raised from January 20th, 2025 through my last day as General Counsel on February 7th, 2025. Accordingly, from January 20th, 2025 through February 7th, 2025, no employees on probationary periods were terminated by the CFPB.
All right, and so now we move on to February 6th and 7th, and a pseudonymous CFPB employee, Drew Doe, says, can you hear me? Yeah, okay. All right, this is from a pseudonymous CFPB employee, Drew Doe. On Thursday, February 6th, and Friday, February 7th, 2025, employees of the United States Doge Service visited the CFPB and were given CFPB laptops. Contrary to the affidavit of Adam Martinez, those Doge employees had not, and to this day still have not, completed the required cybersecurity and privacy training. In addition, contrary to CFPB policy, they were allowed access to CFPB systems and data before an agreement between CFPB and Doge regarding their work was signed. On February 7th, Doge employees were given full privileged access to CFPB systems and data without following the process that CFPB ordinary requires to do. Nor was any document waiving these requirements signed by an official with the power to authorize such a waiver.
February 10th, Peyton Diatalevi. Sorry, I'm butchering that, but I'm rooting for you as you're inside, and thank you again. NTU National Council. Mr. Martinez states that on February 7, 2025, NTU employees began protesting outside of CFPB headquarters building. But we know that's not the truth, right? I believe that statement to be false. As a practical matter, the CFPB headquarters building is located directly across 17th Street, security gate to the White House complex at 17th and G Street. If a safety or security threat was posed by any nearby protest, one would expect a rapid police response given such close proximity to the White House, and no such response occurred during those protests. Mr. Martinez's declaration omits that not only did CFPB close its headquarters, it also closed the 4 regional offices across the country. The email from Mr. Martinez announcing the closures did not identify any safety concern or any rationale that would justify these regional offices. This is because they are running scared. They don't want to see us in person. They don't want to come outside. They don't want to confront us because we will win.
All right, on February 11th, pseudonymous federal employee Blake Doe says, Mr. Martinez's declaration also states that the Bureau has made no attempts to transfer any of its funds back to the Federal Reserve. But I have seen an email dated February 11, 2025, in which Mr. Martinez stated that Chief Financial Officer Daphne Guy was in communication with the Federal Reserve about how to return money to either the Federal Reserve or the Treasury. Matthew Pfaff, Chief of Staff, CFPB Consumer Response, says on February 11th, 2025, the CFPB's Chief Financial Officer, Daphne Guy, requested that offices review a list of contracts to determine which, if any, cliffhanger, directly supported a statutory requirement. I reviewed the list of contracts managed by Consumer Response and determined that 5 contracts directly supported a statutory requirement. And as a side note, a reminder that Consumer Response is statutorily required. It is work that we have to be doing to protect the American consumer. All right, and editorializing. All 5 contracts were nevertheless terminated for convenience after it was determined that they were necessary to support the statutory requirements.
Okay, February 13th, we hear from pseudonymous federal employee Alex Doe. Around February 13th, my team was directed to assist with terminating the vast majority of CFPB employees as quickly as possible. The termination was to proceed in phases to be completed in rapid succession. First, the Bureau fired all probationary and term employees. Next, the Bureau would fire approximately 1,200 additional employees by eliminating whole offices, divisions, and units. Finally, the Bureau would reduce altogether within 60 to 90 days by terminating most of its remaining staff, leaving a Bureau that could not actually perform any functions or no Bureau at all. February 18th, Adam Scott, the CFPB Director of Digital Services. On February 18th, I was CC'd on an email from another employee to Chief Operating Officer Adam Martinez and Chief Information Officer Christopher Chilbert, requesting authorization to work to repair the CFPB's homepage. The employee reported that members of the Doge organization had deleted the homepage for some unknown reason. He detailed the ways in which the broken homepage had damaged several aspects of our technical operations already. I was also CC'd on Mr. Chilbert's response, sent approximately an hour later. Mr. Chilbert denied authorization, stating, "My understanding is that the decision to delete the homepage was made by Acting Director Vogt, and it was not an error made by the members of the Doge team. We do not have authorization at this time to restore the homepage."
All right, during that same time, we have another declaration from CFPB employee Drew Doe. Thank you again, Drew Doe, for standing up for our CFPB and telling the truth, speaking truth to power. During meetings about the CFPB shutdown that took place between Monday, February 18th and Tuesday, February 25th, that was after the court order that paused all of the work, that paused the firings. Remember that. During meetings about the CFPB shutdown, staff were told by senior executives that the CFPB would be eliminated, except for the 5 statutorily mandated positions, that the CFPB would exist in name only. Boo! That once this court injunction was over, everything would either need to be removed from the building or destroyed. Boo! Staff were told by senior executives that the CFPB would no longer have an employee location and that the data could not be stored at any CFPB location because there would be no locations left. Staff were told no DHS, OIG, GAO, OMB, internal controls, congressional, or other compliance would be necessary because the CFPB would not exist. It would no longer be our problem. There has been no attempt internally to hide the fact that the disassembly of the CFPB continues despite the court orders. The status quo as of February 14th has not been maintained. When senior executives were approached by staff about the inaccuracy in the affidavits by Adam Martinez, the senior executives stated that they were not going to discuss the facts, and staff were told to stop asking.
Talk about cowards. They don't even want us to ask. Ooh. All right. February 27th, Eric Halpern, former CFPB Enforcement Director, says, as of February 27, 2025, the acting director of the CFPB has voluntarily dismissed with prejudice 6 active litigations that CFPB was prosecuting in federal court. The CFPB complaints had alleged that consumers in these cases experienced billions of dollars of harm. Before this, the CFPB had voluntarily dismissed only 1 case in its entirety without relief to consumers in the previous 13 years of its existence, which spanned 3 presidential administrations, Obama, Trump, and Biden, and that case was dismissed without prejudice.
Payton, NTU National Council. CFPB employees also received an advisory that as of February 28, 2025, the CFPB's virtual desktop, that is the program that allows employees to securely log in to CFPB system when they are not on the CFPB computer, will no longer be available. This is a timeline of trying to take us down, but we will win. We have people right behind us in that courthouse. We have people who have volunteered their time. We have you guys out here in the cold and trying to stay warm in the sun to come and fight for them. We have so many people who've been on TV, taking a risk, come from California to come help us to protest, people who brought their family and friends because they understand the work that we are doing. We will not let them win. We hear this timeline. What are they taking from us? What are they taking from consumers? The data that they've stolen, the way that they cowardly tried to run after the cover of dark to take our letters off of the building to act like we don't exist. But we are still here, and we are still in the fight. Yes, so we're going to have a closeout from Soul, and we will let Soul continue to manage the program. But we are still here, okay? And we are still in the fight. Keep it up.
All right, so as you you can see, this is a group effort, right? We do this together. We work together to band together and make ourselves stronger by fighting for one another. We are going to hang out and enjoy some of these delicious Costco croissants and donuts and coffee, be in solidarity with one another while whatever happens is going to happen inside. But the most important part is to remember that we are going to keep fighting. No matter what happens in there, we're going to stay out in the streets. We're going to keep spreading the word. We're going to keep telling the members of Congress that they need to stand up and fight back for us, just the way we stand up and fight back every single day for the American consumer. Thank you all for being here. We're going to hang out and be together. Be with one another as we continue this fight.
All right, thanks, you guys.
I know. Consumers are worth fighting for. Dodd-Frank is pretty great. 1, 2, 3, 4. Consumers are worth fighting for. 5, 6, 7, 8. Dodd-Frank is pretty great.
Okay, this one, hey, hey, ho, ho, Elon Musk has got to go. Hey, hey!
Ho, ho! Elon Musk has got to go. Hey, hey! Ho, ho! Elon Musk has got to go. Hey, hey! Ho, ho! Elon Musk has got to go. Hey, hey! Ho, ho! Elon Musk has got to go. Hey, hey! Ho, ho! Elon Musk has got to go. Hey, hey! Ho, ho! Elon Musk has got to go. Hey, hey! Ho, ho! Elon Musk has got to go. Hey, hey! Ho, ho! Elon Musk has got to go. Hey, hey! Ho, ho! Elon Musk has got to go. Hey, hey! Ho, ho! Elon Musk has got to go. Hey, hey! Ho, ho! Elon Musk has got to go.
How do you spell corruption?
E-L-O-N!
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 I say people, you say power. People,
Power!
people,
Power!
I say people, you say power. People,
Power!
people,
Power!
the people,
United will never be defeated.
the people,
United will never be defeated. The people united will never be defeated.
the people,
United will never be defeated.
the people,
United will never be divided.
the people, united.
Will never be defeated.
Woo!
They do.
Thank you.
Did you find it?
Yeah.
Good. Yeah. They were right.
exactly like the wholesale supervision of agency management.
Really?
Yes.
We've seen receiverships in the courthouse, and they impose monitors, and they have people that go in and check and make sure everything's going on, and they have reporting requirements. All I'm saying is the statute says do X, which is what you're saying, oh, we're doing it anyway. So why, if you're doing it anyway, and everybody's daily sending out emails telling everybody do what's required, what is so offensive about the preliminary injunction that confirms she's going to do that until the merits of this case has been decided?
The acting director believes that certainly in all the areas, at least in the February 8th email, which I think is impossible and one should not look at the February 10th email without reference to the February 8th email.
But I'm telling you, I don't have a problem with the fact that 3/4 of the February 18th email overlap. And I assure you that I don't think anything in the proposed TRO or anything I would ever issue would say you need to get back to enforcing, you need to get back to litigating. I mean, the judges, the individual cases have different points of view about that. Or you need to get back to revising regulations, issuing regulations, promulgating the ones that were 3/4 of the way through the notice and comment process before. That is the ordinary operations of an agency under the political leadership of the administration. I understand that. But we have a funny statute that doesn't just say, agency, you have broad authority over X. It says the agency must do A, B, C, and D. And so that's all we're here to talk about, is A, B, C, and D.
So let's say, for example, that you entered an order consistent with paragraph 6. It says, defendants shall resume and take no further action to suspend the Office of Consumer Response. Well, let's say in our view, Chief Legal Officer and or the agency leadership decided that the Office of Consumer Response needed half the staff than it currently has in order to maintain its statutory obligation. And actually, I think that's consistent with what the declarant in their case suggested might be appropriate and what was approved. Now, they're going to come in and say that, actually, we need more staff. They're violating the court order. They're suspending the Office of Consumer Response because maybe they're not responding to employees.
But at this point, they have no staff. So that's the point. We have to get past that. I cannot dictate you need 10 people, you need 20 people, you need 3 people. But I need to know that somebody's getting back to the people who call.
The way the APA contemplates that Your Honor would address those questions is through the request for adjudication of concrete agency action.
So are you saying if it decides that's 5, that's a concrete agency action? I thought they said all these employment decisions aren't challengeable through the APA anyway, and the only thing they can do is all go run and file Merit System Protections Act cases, correct?
Suggesting like a consumer, right, who files a complaint and isn't having their complaint being processed would bring a 706-1 claim claiming that there was an unreasonable delay or an unreasonable withholding of that complaint. And the agency, through its own management, would have to ensure that it does process the complaint insofar as they meet any other threshold requirements. That's how this works. It's not through submissions of declarations from every agency head of every division saying that we're doing our work. That is wholesale oversight of the agency's management and consistency of the law.
I think what we're talking about is interim oversight to make sure that it hasn't been choked out of its very existence before I get to rule on the merits.
I think we respectfully disagree that that's how preliminary injunctions goes.
Well, I think then we probably should go on and get to the merits, but I am very much thinking that after I see whatever everybody else files, we may need to have an evidentiary hearing. A lot of what Mr. Martinez says seems to be carefully wordsmithed, and I'm not saying that in a, to say it's disingenuous, but it sidesteps what I'm really trying to figure out in remarkable ways when it says things like the consumer response data system is operational. That sounds to me very mechanical, and I'm interested in humans.
Your Honor, we don't think that any evidence is required because of the legal issues that preclude plaintiffs moving forward. But that being said, if Your Honor wants to hold an evidentiary hearing, I think we can prepared to address that, and we would just request the plaintiffs bring their declarants as well, because we have a number of questions for them with respect to the declaration filed last night. Makes it seem as if, despite the fact that they're being told to work, some of these folks closer to the ground level and middle management are telling each other not to work anyway, and they can't take necessary intervention. And so we would have a lot of questions for them on that.
Well, that's the whole point of an evidentiary hearing. They will have the opportunity to cross-examine your declarants. You'll have the opportunity to cross-examine their declarants, and that's generally how facts get found in the system anyway. So we may have to do that, and if we have to do it, we're going to have to do it in short order. One question I guess I have for you is the same one issue I raised with the plaintiff, which is there's a certain amount which you agreed to pending this hearing. This hearing isn't going to be over, so we have the next hearing, and really that's not going to be over until I rule. So I think it's going to be essential to figure out whether we can continue to freeze the situation the way we have by consent between now and when I rule on the legal issues that at least the likelihood of success on the merits on the legal issues that you think govern the whole thing anyway.
So are Your Honor referring to the temporary restraining order?
Right, with the little side agreement that you have about necessary contracts, which is the data right.
So the order that we agreed to, I think it was February 14th, I can't remember. That email extends until this court decides the preliminary injunction, and we're not asking the court to modify that. We do have an agreed upon agreement in which that the contract review process has been entirely frozen just until this hearing. We're not going. The defendants really can't agree to extend that. I mean, that wraps up all of the contracts.
You can't tell me that the Office of Consumer Response is up and running. Don't worry about it. If the contractor required to make the computer do it is about to run out of contract.
The contract issue is at an incredibly high level of generality involving all number of contracts, right? So, for example,
you should be
so it's an incredibly high level of generality. It covers all contracts. We're not talking about contracts like, and to be clear, Your Honor, I mean, my friends on the other side essentially represent the entire staff of the agency. We have asked them to, and they have not been able to tell us what specific contracts they're worried about. They don't want to do that because that's not really what's at issue. So my clients have been going through a process of, for example, going through which enforcement actions are within the enforcement priorities of this administration. A number of those proceedings, some of which have already been dismissed, have contracts with expert witnesses.
I don't think they're talking about that. I think you can easily have a conversation and figure out what they're talking about. I think I can figure out what they're talking about. Question is if we can zero in on the ones that relate to the operations of the Office of Consumer Response. I think that ought to be something that can also, along with what you've already agreed to, await a ruling on the preliminary injunction.
Your Honor, in our view, the plaintiffs came in with their complaint and their temporary restraining order weeks ago, and I think we can't agree to have this continue to shape-shift. If that's what they wanted, they had an opportunity to work with us on that issue. Insofar as the court wants to enter
I think there's shape-shifting on both sides, and that's why. I think you went from saying we're not going to do anything to now saying, well, actually, yeah, I guess there's really some things you have to do, and they want to make sure it's actually happening. And I think it's positive shape-shifting on the government side, and the plaintiffs need to give credit where credit is due if things are actually happening. But it's an evolving situation. It's true.
Your Honor, if the plaintiffs have satisfied the criteria for a temporary restraining order, then the court can enter one. We would ask that if they're going to do that, it would be a modification of the existing order, and it would also be subject to the 14-day time in the federal system.
The existing order is not a temporary restraining order. The existing order is an agreed order. And I'm talking about whether if there are specific little things needed to make that agreed order work, until we can rule on all of your objections to the preliminary injunction, whether you'd be willing to agree to that. So you can think about that. You don't have to answer me right now. And I'm going to move on to talking to the plaintiff about the merits. And then you'll get a chance to do that. All right. Mr. Gupta, if you only need one count to support preliminary relief, which is your strongest count?
Well, I think the first two, the separation of powers count and the FVRA count, but I will say that the APA count is substantively very similar because, as we've been discussing, there are statutorily required functions. They simply aren't happening. The government's defense of the lawsuit, if you look at their brief, is really defending a world in which the agency has done something that's more like a typical transition, where they haven't said, stop all work. And so I don't even think the government is actually mounted a legal defense of the scenario that we've actually presented factually.
All right. Well, count one was essentially the ultra-virus action, the statutory violation that is eliminating an agency that Congress created, correct?
It's the dismantling of the agency and then the discrete actions that they've taken in service of that plan. The FVRA
And the FVRA, that case claimed, they've already now officially nominated a new director. Is that correct?
They have, but until such time as that person is Senate confirmed, the question is whether acting director Vaught has been lawfully appointed. And he has not, because he was appointed pursuant to the Federal Vacancies Reform Act, which doesn't apply.
Talk about that.
Yeah.
I'm not sure, and I know there's a specific provision in the statute as to who the acting director should be.
Correct.
But is that still good law after Celia law?
It is, yes. Celia law is about the president's authority to remove the director of the CFPB. And so we don't quarrel with the fact that the president can remove the director of the CFPB. But this is a question of how can he appoint a temporary head before there's Senate confirmation.
It doesn't every sentence in Celia law that talks about they remove or appoint?
I don't deny that under Celia law he can remove the director of the CFPB. But the question is, in the interim, before there is a Senate confirmation, basically the question is, which statutory provisions apply? Does the FVRA apply, and does the automatic succession plan under the Dodd-Frank Act apply? And I think if you look at the English versus Trump case, that was a debate about whether those two statutes can coexist. You can be agnostic on that question. You can think that Judge Kelly was right in that case, that both of those statutes can coexist. And here the question is a more specific one, which is, does the FVRA apply in a scenario where the president has removed the person? So there wasn't...
Putting aside the Vacancies Reform Act for a second, let's just talk about the ultra-virus notion that this is contrary to a statute that clearly said this agency should exist and it has a job to do.
Right.
What is your best case authority for the fact that that gives me authority to tell them do something?
I mean, Youngstown. It's such an elementary proposition of the constitutional law that the executive cannot decide without congressional authorization to unilaterally dismantle an agency that Congress has created or deprive it of the ability to fulfill its statutory functions. And I think it's so elementary that that's why the Justice Department...
So elementary that it's very hard to find it written down anywhere. So I just wanted to know if there was a particular case since Youngstown that you wanted me to focus on.
Yeah, I mean, the other case is the base closure case, actually, that my friends rely on, the Dalton case. And I think that case actually is pretty helpful for us because it acknowledges that where Congress has committed the discretion to the executive to close something, then of course the executive has that discretion. But the negative pregnant, which the case gets into, is that where Congress hasn't done that, the executive lacks the authority, and that's the kind of claim that we have here. And again, I don't think my friends on the other side, with respect to them, they're not really denying that. What their brief says is that's not happening. So it's a factual debate. But I think on the legal proposition they're not really contesting, and I think it would be very difficult for them to contest the legal proposition that the executive has the authority to do that.
Well, counts 2, 3, and 4 then invoke the APA as their basis for relief. And as we all know, the APA requires final agency action.
Correct.
Count 2, that's where you identify the appointment of as being contrary to statute and the Federal Vacancy Act as a final agency action. How does that fit the paradigm, since that's not something the agency
Right. I think the better way to think about it is we are making an appointments clause challenge to that appointment. We're obviously injured by actions that Mr. Vaught has taken. And so in an appointments clause challenge, as long as you have action that has been taken by someone who's unlawfully appointed, you don't have to ask the final agency action question, right? It's not an APA claim. It's a claim under the Constitution. And there's no question here that a series of actions have been taken by Mr. Vaught, in particular the February 10th stop work order. That's an action that was taken pursuant to his authority as acting director. If he doesn't have that authority, that was an unlawful directive.
Okay. That's not actually in the complaint right now, though, right? What you said was that it was the appointment that was the final agency action?
I mean, if we drafted it a little inappropriately, we were moving fast, but I think the substance of that claim is an appointments clause challenge to his appointment and therefore the actions he's taken pursuant to that appointment.
And count 3 under the APA challenges actions intended to suspend or terminate mandatory activities, and you see they're contrary to law. And count 4 says that actions intended to suspend or terminate activity are arbitrary and capricious. Now, are actions suspending activities reviewable at all? They're not final, it seems to me.
So I wouldn't say that it's just suspension of activity. I mean, maybe the better APA hook is unlawfully withheld. Again, if we need to amend the complaint to make this clear, we will. But this is, I just want to back up for a second and stress that this is an unusual situation where the executive has unilaterally decided not to undertake the required statutory functions. And so if you run that...
Count 1?
Yeah, no, but if you want to think about it as an APA matter, what I was about to say is that if you run that through each of the sort of elements of the APA, it fails each one. It's contrary to law, it's unlawful, it's agency action unlawfully withheld, it's arbitrary and capricious, it's all of those things. It is such an unusual situation for the executive to say, I understand that Congress has required this.
What is the final agency action? Stop work?
Yeah, I mean, that is one of them. There's also the directive to cancel all of the contracts. And if you look at the Charlie Doe Declaration, it makes it clear this was not, an individual contract that was canceled. This was a directive to cancel all of the agency's contracts that the agency needs to function. And that declaration explains how integral these contracts are to the agency's functioning. So does the Meyer Declaration, the second and third Meyer Declarations. So those are agency actions. And then, of course, there was if this court had not entered the order on Friday, February 14th, it is pretty clear from the record now there would have been a mass firing of almost the entire agency that evening.
So when has the APA ever been used as a mechanism to challenge how the agency manages itself as opposed to how the agency manages substantive area under its purview? What you're saying is it's canceling. I can look under the APA and an agency's decision to cancel contracts. I can look under the APA and an agency's decision to fire its employees. You have any cases that say that?
Yeah, I mean, so we're in uncharted territory here where the executive decides.
So that's a no?
No, I mean, I think the USAID case is an example where they said we're going to...
So the other cases going on in this building in this very moment?
Yes, I mean, that's the most analogous case because government has never done this before. But it canceled all of those contracts and the order said, enjoined that. I also say we represent people on all ends of this. We represent National Consumer Law Center, its largest contract it publishes books on consumer law. Its largest contract was terminated by the CFPB. And we represent the people who are trying to perform these functions and all of the stakeholders of the Bureau. And the Bureau cannot do it.
Promised you that time. Yes, they did. His lawyer said he's going to get 18 to 24 months. And the judge will say, did anybody promise you that? Yes, his lawyer told him he's going to get 18 to 24 months. How did he get more? And the lawyer said he's going to get that.
All right, man, we report live, man. Report live from D.C., man. You know what I'm saying, man? Yo, we the best place, man. Yo, you know what I mean? Good morning, man. Report live from the court building, man. Today, we're going to discuss. bruh. Hey, this down. What is it for?
Does that keep the sun off the lens? Instead of putting like a little sparkle out there.
Oh no, I got my fault, bro. My fault. Nah. You're right. Have a good day.
It's a nice camera, man. Thank you. Have a good day. Appreciate you.
Don't say that. They were. I'm from Texas. Same thing. Yeah. He startled me.
Of course, that's what you think of,
Right.
Isn't that funny? So are you going back and forth to both work later on today?
No. Is somebody pleading today? No, I wanted to see what you guys had gotten because, oh yeah. Well, I had to pick up some folders to secure for you. And yeah, well, I've seen this case and yeah, I mean, I've done superior court, but I've never done federal court, so if I would just want to learn about this stuff. It's my personality a lot better. I don't like that just like quick felony. It's terrible. Yeah, and they don't like it if you take your time and they want you to do mass numbers. You still practice it? No, what I'm saying in federal court, like we're the third attorneys in a couple of cases on our being together, there's turnover.
repeat, they're stressed out, and if you don't have that rapport with them, you usually get switched out pretty quickly at the beginning. There's something to say for it, you know. At first I was pretty shocked. I was like, wait, what are the defenses here? I mean, even if you knock out 2 or 3 on technicalities, I mean, what's yeah. No, I got pretty good at that security part. It was kind of fun, but you don't have that. But I'm okay with that. I think that there'll be some sort of legal ruling about what happened. Well, but yeah, you're right. You hit on it. Litigation, very key.
See you again.
Yeah, I found a great parking spot. Yeah, use up all my time. My $5 worth. Yeah. I got it.
Catch anything good?
Huh?
Catch anything good?
No, no fish today.
No fish today.
No fish.
Still out here just in case?
They just put me here. I get paid, so.
Sweet. Good luck.
Thank you.
estar firmando algún tipo de declaración famosa o algo así que nos puedan dar.
que los habían puesto todos en
any lawyers that come out?
Any lawyers?
Nobody's.
Nobody's.
We're just here for cases.
Thank you, lawyers.
To move forward, it's really nice.